I'm Professor Marc-André Léger, and this is the recording for week 4 of Business Technology Management, Business Information Systems Risk, Security and Audit, BTM 440. In this lecture, we're covering U.S. compliance laws, and I do want to remind you that these are the laws that apply to for information security and standards in the United States. So we're going to look at those from a Canadian perspective, as we're located in Canada, and our focus is on Canadian issues, but this also connects to the use of American laws, as many organizations are multinational and so do operate in the U.S. regulatory space. However, some of those are less relevant, and so we might be going quickly over those. So as you'll notice, this is a big slide deck, and we're not going to cover everything, but the main idea of compliance is important to us. This is an important issue for businesses as it relates to cybersecurity. The idea that as an organization we need to comply with some laws and regulations. Also, we have contractual obligations that make us need to comply to certain standards as well. And we will want to implement some frameworks, such as the NIST Risk Management Framework, which will help us to put in place quote-unquote good information security. Best practices or ways of doing things that have shown to be successful for many organizations and have led to the creation of risk management frameworks or international standards. So, but when we are talking about compliance, we are focusing more on the legal aspects. So, depending what sector of activity we're in, we may have national laws, regional laws, international treaties, or international agreements that would apply to us, depending on our sector of activity. In the US, as in Canada, organizations that have sensitive data, in particular personal identifiable information, PII, so basically what we might think of as private data, there are certain laws that require us to protect this data. Whether we're in Europe, in the US, in Canada, they are equivalent laws. Some of those are a little bit different, but they tend to be gradually evolving to become more similar. And that's certainly the case in matters of data protection law and privacy. So currently the EU GDPR, so the general data protection rules in the European Union, are much more strict, but California is adopting similar laws now, and Quebec in Canada as well. So these are becoming more and more similar over time as people adapt. I do want to remind you that respecting laws is not an option. It's a legal obligation to respect the law. So, as it relates to these, particularly to personally identify information, PII, we need to we need to comply with the different regulations in this regard. So when we're talking about personally identifiable information, this includes your first, middle, last name, your home mailing address, your social security number, your driver's license, your Medicare card number, your financial account data, all your health data, biometric data, and all your authentication credentials, so user IDs and password that you're using to connect to the various systems. So these are all considered PII, and these are all going to be covered particularly by many of the laws and regulations and standards that we have to deal with. So as an organization, from a legal standpoint, we obviously are required to follow the laws and regulations that applies to us and to our industry. However, in order to do that, we need to interpret them in a way that the policies and procedures So the documents that we're going to be using internally can be defined, can be understood. So this is a very delicate situation, particularly in the context of Quebec, so our context here, where legally there's there's a law that declares who is allowed to interpret or to make opinions about how laws apply to people and to organizations. In Quebec, only lawyers and certified notaries are the people who are allowed to give legal opinions. In a educational context, professors as well, law professors may as well do that. Obviously, judges is a whole different thing, because at that point it's not really interpreting them in an organizational context, but it's once it gets to court. So, but at the same time, people like me, cybersecurity professionals in organizations, we can't always necessarily go and talk to a lawyer every time we need to make a decision or apply certain regulations in the context of our work. So this is a very delicate balance. But legally, in most jurisdictions, and it is the case in Quebec, only lawyers can give legal opinions. So there's the law on the Quebec Bar Law Association law that applies, and it defines that only lawyers can do things like that. And in some cases, corporate law can also be interpreted by certified notaries, which has a legal sense in Quebec that is different from the rest of Canada and most of the common law countries, because we have civil law that applies in Quebec as well as common law for historical reasons. So from an organizational point of view, we need to create policies. So we need to have a security policy. We mentioned that in a previous class before. But then the main security policy will lead to other levels of more detailed policies. We're going to create standards. We're going to create operating procedures. We're going to create guidelines, and that are going to need to be followed by the different stakeholders inside of the organization. And so as cybersecurity professionals, people working in the field of governance, risk management, and compliance, GRC, in the organization, we're going to be putting in place this structure of governance that's going to help the different individuals that need to apply them in their day-to-day jobs. It'll help guide them in doing what they need to do. So this is an expertise that has to be developed inside the organization, and this has to be done in coordination with the legal department to ensure that we don't make any errors, that we stay within the limits of the law. So privacy and information security are related. Privacy, if you, and maybe this is a discussion that we can have in the Q&A session if it's something that you're not familiar with. But hopefully in your other courses, such as COM226, the core program course that relates to information technology, you had this discussion, which I normally have with my students, about the difference between ethics, the law, and privacy. And this concept that privacy is a human right. And so you as an individual, you have a right to choose, how your private information is disclosed. But there's also laws that apply to that. And like in Quebec, the law on access to information, or PIPEDA at the Canadian federal level, and other laws that apply in specific areas, as similar to the ones that we'll be talking about or going over in this presentation. But because of this obligation that we have to follow these laws that concern privacy of information, then we have to keep certain information confidential. So what we're doing in information security, if you remember CIA, confidentiality, integrity, availability, so that's what we're looking at, confidentiality. And so privacy, as it applies to how we need to manage information, gives us some confidentiality obligations. So in cybersecurity, we're managing confidentiality, and some of the confidentiality that we need to maintain is due to the privacy regulations that we need to follow. So I hope that is perhaps helps you to understand how these are connected. So when we have an obligation of privacy towards a customer, the customer will inform us to, will give us permission to use this personal data because he wants some services from us. And in exchange for that, to maintain the confidence of the customer and to maintain our reputation as an organization, we'll put in place certain confidentiality controls and guidelines so that we will fix inside of our organizational policies, procedures, practices, business processes, how we can use, how we can maintain, how we can copy, how we can transmit this private information of customers, which for us is confidential information. So I hope that makes sense. Again, perhaps it's something that we can explore a little bit more in the Q&A if this isn't clear to you. So federal information security, again, this is in the U.S. context. So in the federal government being a very large creator and user of information in the U.S., and so they have obligations of how they can manage information because obviously, information is very critical for the operation of the government in order to do what they're doing. As well, the government has to maintain a lot of very, very sensitive military data. This presentation, as I said, is in the context of the US, but you can just change for Canada and it's pretty much the same issues. So there's the Federal Information Security Management Act, FISMA, that applies. This applies only to US government agencies, federal agencies, and which requires them to do a certain number of things. So do risk assessment, an annual inventory, policies, procedures, plans, security awareness training, etc. Again, all U.S. agencies must put in place mechanisms to protect the information. They must do a yearly test. They must review their controls and ensure that they have accurate, well-functioning, and sufficient controls in place for the organization. Make sure that they work, and then continuously manage risks. So really, it defines the roles, responsibilities, accountabilities, requirements, practices needed to fully implement the FISMA security control and requirements. So in Canada, we have the equivalent to that. Now in the US, the National Institute of Standards and Technology, NIST, creates all the guidelines that federal agencies use for their information security program. And it creates standards that they use to classify the data. It creates guidelines and minimum information security controls for information systems. And it creates the Federal Information Processing Standards, or FIPS, and the special publications. So there's a whole bunch of those FIPS and special publications, which are created for use in the US. But however, we in Canada rely quite heavily on those. They're probably some of the best documentation around on how to implement cybersecurity in organizations. So, for example, in my work, my day-to-day work in cybersecurity, I rely on the National Institute of Science and Technology. Special publications is really at the core of what I do, all the ones that have to do with security awareness, security training, competencies, the workforce planning, which is the area that I'm more active in cybersecurity, and it's all based on NIST standards. So this is the risk management framework recommended by NIST for the FISMA compliance, but also can be used for many other risk management requirements. So this is a 6-step process that is used to protect federal IT systems. The first step is categorize the information system. So this is where an agency must sort its IT systems based on risks, so meaning they must do a risk assessment. Then select the minimum security controls. So this is where an agency must select the controls for its IT system based on their risk categories. Then implement security controls in IT systems. So then you apply the controls in certain areas that are specified by NIST. Included in these areas are access control, contingency planning, and incident response. Then assess security controls for effectiveness. So this is when you assess the controls on a continuous basis to make sure that they're effective in reducing risk. Authorize the IT system for processing. So an agency must test its IT systems and approve their operation. An agency specifically must accept the risks of operation prior to allowing a system to operate. And this process is known in FISMA terminology as certification or accreditation. And then finally, continuously monitor security controls. So monitor the security controls continuously to make sure that they're effective, and also document any changes to the IT systems and assess the changes for new risks. So national security systems, these are the systems that are in place for activities like intelligence, so like the CIA, places like that. For national defense, so the military, foreign policy, military activities. And so there's a committee on national security systems that oversees the FISMA activities for those, and it's the same six-step process that is being used. So some of the risk frameworks that may concern us to a certain degree, or that for which we have equivalencies in Canada. And here we're going to quickly go over these, so to give you an idea of what they are. And I invite you to go further in the book, read in the book for the details about that. So the first one here is the HIPAA, so Health Insurance Portability and Accountability Act. So this is for hospital, healthcare providers, insurance companies in the field of healthcare. And this would apply to Canada, particularly for insurance companies or pharmaceutical companies that are doing business or doing lab work for the healthcare system in the US. Also, in some cases, for research purposes. And so here we're looking at the personal health information. So this is the personal individual identifiable information, but specifically the one that's used in healthcare, so electronic healthcare records and things of that nature. The main requirements are the idea that we need to protect the privacy of this information. So again, if you're not familiar with the concept of privacy, I've added another video that talks more at length about the concept and what it includes from the COM226 course. So this might give you an idea if you didn't take it with me. And so there's a few exceptions of information that you are allowed to transfer without the permission of the patients. But most of the time, the big idea is to keep in mind that the electronic healthcare information belongs to the patient. So we need their permission, we need consent, and more so we need informed consent. So there's a whole bunch of different safeguards that are required. But the basic idea, as with all of these frameworks, is the need for risk and the need for a decision-making process based on risk to be able to treat private information. So a whole bunch of different particular safeguards that would apply. And again, here in Canada, and in particular in Quebec, we have equivalent regulations that would apply to the field of healthcare as well. So of how you can use information, how you can process information, how you need to protect the systems that are in place, the workstations, the networks, and different requirements as far as audits and authentication of the users on the system. So there's oversight for HIPAA as well. So there's different organizations in place. The Office of Civil Rights in particular is responsible for the enforcement of HIPAA in the US. And so there's different regulations as well, and the omnibus rules, so different rules and regulation that come and tighten the requirements covered by HIPAA. In the financial industry, we have the GLBA, so this is the Graham-Leach-Bliley Act. This is basically the name of the people who presented this bill, who sponsored this bill in the US Congress. And so this has to do with privacy and security of consumer financial information. So it basically puts in place requirements for data management and cybersecurity as it relates to systems that processing financial information. So things like credit cards, bank accounts, things like that. It's basically a U.S. law that needs to be followed by financial institutions in the U.S. But Canadian organizations who are doing business in the U.S. would be concerned with this regulations. And so many agencies are involved in this process. The SEC, Securities and Exchange Commission, the Federal Deposit Insurance Corporation, Credit Union Administration, Controller of the Currency. So they all have different roles to play in overseeing different parts of the U.S. banking system. So some of the main requirements that we need to know about. So how a financial institution can use information, and the fact that it can't share this information without the consent of the customers. It must inform them of what's happening. So it's basically a little bit like in HIPAA and like others that we'll be talking about. You got to protect the privacy of information. You have to protect the secrecy and confidentiality of customer data. You have to protect it against threats to the security and the integrity of consumer data. You need to protect against unauthorized access or use of customer data that could result in harm to the customer. And you require financial institutions to create a written information security program. Shouldn't really come as much of a surprise when you think about it. I mean, considering, that's pretty much what we've been talking about all along, that all organizations need to have these kind of things. Now, in the case of GLBA, to make it a little bit more, give it a little bit more power, there are monetary fines that could be given to organizations who don't support it. Sarbanes-Oxley, or commonly known as SOX. So this is to protect investors from financial fraud. So it has to do with how we need to put in place, rules on how we manage financial information, reporting, etc. But also Section 404 requires the executive officers to take responsibility for that. So basically, we can send people to jail if they mislead investors, or if they knowingly provide erroneous financial information. And so, they don't want to go to jail. So they're careful. Now, keep in mind, this was created after some major financial frauds that happened in the 90s and early 2000s, when this became necessary for the U.S. government to do that. Now, this would impact Canadian companies because, of course, a lot of Canadian companies have a presence in the U.S. markets, particularly for stocks and bonds. So here there's control requirements and certification of the controls that need to be done. So we must create, document, and test these internal controls, and we must report on them, and we must make a yearly report using outside auditors that are going to come in and review. And then if there's something that's identified, we've got to correct it, and we have to put in place reasonable assurances that these reports that are being done are reliable. There's also some requirements for records retention. So this has really big implications from an IT point of view, because it means we got to keep copies of information. So considering that most of the information today is electronic, so this has a lot of implications, on how we can manage financial information and things like emails and reports and documents and exchange of information between the different stakeholders. So this is something that would definitely have a lot of IT connections. And so there's a lot of things that we're going to need to do in order to put that in place. So this is put in place this is overseen by the SEC, so the Stock Exchange Commission in the US. This next one I'm just going to fly over because this is really for educational purposes. So even though this is for the education sector in the US. And so this definitely wouldn't apply to us. In Canada, it would be the federal privacy laws and the provincial privacy laws that would include that. So I'm just not going to cover it in this presentation, but do know that any school in the U.S. that has federal funding would be subject to this. And the Child Protection Laws, Child Internet Protection Act, CIPA in the U.S., which is there to protect kids from under the age of 17, so that in schools and libraries and any federally funded program, they must have in place some kind of mechanism to protect children from unauthorized content. This one is more important to us, and certainly to me personally, as I work in the financial sector. The Payment Card Industry Data Security Standard, commonly called PCI DSS. And this is for anybody who's doing processing of payment system cards. So like Interact cards, your bank cards, the credit cards, any type of payment system, in order to be able to connect to the network. So think of Visa, MasterCard, American Express, all these big international clearing houses for credit cards. In order to connect to them, either as a merchant, so somebody who's taking them, the cards, or as a processor of cards, like most banks who offer credit cards could be, or as an emitter. So if somebody who's creating these cards that you're giving to customers. So those are three different areas where you would have some different requirements that would apply to you. And so you need to, according to what your role is, then you would have different requirements that you would need to fulfill, and that's the next slide. But here, keep in mind, it's there's a qualified security assessor, so basically an auditor that's qualified for PCI DSS, who's going to come in and audit you, and then so that's got to happen on a regular basis, and depending on what your level is, what your status is within the system, whether you're a merchant or an emitter or a processor or whatever. And so that's specified in the standard. And then there's a self-assessment also that you need to do on a regular basis. And then depending on the results of that, then you may have certain actions to do. So there's a whole bunch of different control objectives. There's actually 6 different categories, and there's 12 requirements. These are fairly high level, but they address the things that you do. Now, in the actual standard itself, which I actually use, and I actually did some internal training for my colleagues on that, and there's quite a bit of stuff, but some of the key ones that really that would be concerning us a bit more. So 3.3, the requirement for the primary access number, so that's basically your credit card number. When you're transferring this information or displaying this information, you don't want to send the whole thing. So you want to do like only the first 6 and the last 4. So that way somebody couldn't just guess what the other numbers are. So they couldn't actually, if they intercept transactions or transmissions, they couldn't figure out what the credit card number is. 8.3, so sub-requirement that requires multi-factor authentication for personnel with non-console administrative access. So basically, if you're an admin, if you're an administrator, if you're a root user, if you have, administrative functions onto a system that is involved in the processing of these credit card stuff, then if you're not sitting on the console within the server room, you have to have multi-factor authentication. So more complex, like user ID, password, that's one factor. Then a token, an access ID, or perhaps a biometrics, that would be a second factor. So 2-factor authentication. Or maybe even like, logging in and then sending a code to your cell phone. That would be like acting like a token. That would be multi-factor authentication. This is pretty common, I guess, these days for many things, even like Facebook. But this is one of the requirements of PCI DSS. Remember that, a few years ago, this was definitely not a common thing. 10.8.1 is talking about the requirements of service providers to detect and report on failures of critical security control systems. 11.341, a new requirement from 2018 for service providers to perform pen testing on segmentation controls at least every 6 months. We need to have, like we do, a red team who's doing pen testing. And one of the things they must be tested, at least every 6 months, they must be testing the segmentation control. So how you segmented your different areas of your network, particularly the what's called the CDE, the card data environment, so where card information is actually being processed. The requirement 12.4, so executive management needs to establish responsibilities for the protection of cardholder data and the PCI compliance. So there's got to be somebody at a significant level of the organization who is responsible for this. At where I work, it's a general, a high-level director that is in charge of this, and a vice president that has this responsibility. 10.11.1, new requirement for service providers to perform review at least quarterly to confirm that personnel are following policies and operating procedures. So basically, all of these rules, all of these regulations are part of what it is that you need to do. So for you, as a system security professional, you need to understand these. You need to understand which are the ones that apply to you and how these relate to the systems that you have in place. So here, of course, we're basing this course on a U.S. book, so the Canadian situation would be a little bit different. But hopefully, in our regular weekly Zoom session, you'll remind me to give you some insights onto how this would actually work in a Canadian institution. And so these are some examples of, based on the CIA confidentiality, integrity, availability, the different rules that we talked about, how they would be applying. So that would be it for this short lecture, part 2 of this week's pre-recorded lectures. Thank you.